This is panel 4 in comparative perspectives. I'm Frank Munger. I think my claim to fame, the reason for being here is that I spent most of February in West Palm Beach, so avoided 2 of the largest snowstorms we've had in New York. So if you want to trust foresight, stick with me. We have come to the conclusion, last substantive panel at any rate. We're going to have a wrap up with 2 distinguished scholars after this. It'll draw everything together. We're going to talk about comparative perspectives, and Sam Zakharov's comments on the last panel really brought us to this point, and I think framed a question for this panel. If the question for the last panel was, what do we learn from history? I think the question for this panel is, why do constitutions matter at all? And a global perspective may not give us answers, but it'll give us some new ideas about why constitutions seem to be a source of struggle, a kind of destination for movements in many societies, and yet seem to be replaceable at will in some of them. We have 3 scholars on the panel who can address this for sure, given their backgrounds. Heinz Klug, who's the John and Rylla Bosshard Professor of Law at University of Wisconsin. University of Natal, later from UC Hastings, and then University of Wisconsin, where he's now established. Major scholar, expert not only in the South Africa Constitution, and policy questions related to that, which he's been involved in, but also speaks more widely about many topics related to that. I noted on your video, it says lectures all over the world, and then I have a question in my notes, well, about what? But the answer is everything. So welcome, Heinz. Jason Stanley was going to be on this panel, can't attend, regrettably. Miguel Schor, Distinguished Professor of Law at Drake University, teaches and writes about constitutional law, but what caught my eye as he writes, especially about threats posed by Trump. And one of the recent topics he's addressed is American constitutional exceptionalism and democratic erosion, defending democracy, a comparative perspective. And it seems it's a really timely knowledge and perspective to bring at this moment in the conference. And then finally, our 3rd scholar is Gaurav Mukherjee. He's visiting professor of law at University of Connecticut, graduate of the Central European University, a wonderful crossroads for scholarship from really all over the world, but especially in Eastern Europe. And again, what caught my idea, Gaurav, about your resume is that you focus on law and religion. Religion is a big factor in constitutional around much of the rest of the world, not so much, or at least not overtly in the United States, but in many other countries, religion is a major factor. So, Heinz, if we could begin with you, and I will kind of keep, yes, for sure.
Yeah, I'll try and be shorter than that, so I'll read just to make sure that I do that. I took the challenge that was put to us to try and address Jack Balkin's work, and particularly the relationship between constitutional crisis and constitutional rot. And I'm going to be a little outrageous and compare 4 different countries as a way to comparatively think about this. So if I'm happy to accept Balkin's distinction between constitutional crisis and constitutional rot. And I want to use a comparative lens to argue that Ernst Frankel's theory of the dual state provides one way to explore the relationship between constitutional rot and moments of serious danger that herald the constitutional crisis in the form that Jack Balkin describes. Frankel's conception of the dual state also helps us distinguish those moments of what both Levinson and Balkin referred to as constitutional dictatorships, the power of government officials to act on important matters free of accountability or timely legal checks. What they argue is an institutional feature within constitutional democracies that can and should be employed to perform valuable civic functions. So we start with Frankel's dual state, in which the normative and prerogative states coexist. He wrote this actually before 1941. He was writing it already while he was serving as a lawyer in Nazi Germany between 1933 and 1938. And his book, The Dual State, really does focus on what's going on in that period. And it's after the emergency decree of February 28, 1933, signed by President von Hindenburg under the Article 48 of the Weimar Constitution. And a key element of Frankel's dual state is the fact that the jurisdiction of the normative state is limited by law, while the prerogative state has no legally defined limits on its power. So the enabling law of March 24, 1933, which granted Hitler's cabinet the authority to issue laws without parliamentary approval for 4 years, empowered the Nazi regime to issue decrees fundamentally restructuring the constitutional order and creating the Gestapo, which became the primary organ of the prerogative state. Jens Merenhenrich argues that Frankel understood that the institutional effects of this bifurcated state facilitated not only violent domination, but also allowed for an orderly transition to and consolidation of authoritarian rule. If I switch to look at South Africa, South Africa's colonial apartheid order was both a formal bifurcated state from its formation in 1910, in which the African majority was subject to administrative rule by the executive, while colonial society in white South Africa was ruled through parliamentary democracy. It was also a dual state in which the security police and an expanding security system formed the primary organ of the prerogative state, unaccountable to the law, even as the judiciary and government proclaimed the rule of law. Post-apartheid South Africa has experienced significant constitutional rot. So this is where I see the other side of what Jack has been talking about, and even a high levels of social protest and constitutional hardball, which has seen 2 presidents forced to resign, as well as political violence, such as the Marikana, where 34 striking mine workers were gunned down. Yet there is no evidence of the emergence of a prerogative state in which explicit zones of unaccountability emerge and are immune to the strictures of the normative constitutional order. So even as it suffers constitutional rot, the fact that you haven't seen the formation of prerogative elements means that there's an ability to reinscribe the constitutional order again and again in that context. Ghana, sub-Saharan Africa's first state to gain independence from colonial rule, also experienced decades of autocracy and military governments prior to its adoption of a democratic constitution in 1992. Jerry Rawlings' military government helped produce that constitution, ensured that the new constitution granted eternal immunity to all former military leaders, even though they were responsible for heinous crimes, including the disappearance and murder of 3 sitting Supreme Court justices during his term. There are even claims that Rawlings, who was then elected twice as president for 2 terms under the 1992 Constitution, may not have won the second election fairly. Yet he did obey the constitutional term limits, and Ghana has experienced regular changes of governing parties since 2001. Constitutional rot has, however, been a feature, driven by corruption, yet unaccountability has not seen the re-emergence of a prerogative state. And most recently, in December 2024, there was the election of John Mahama in an electoral landslide that has raised hopes of constitutional renewal. The distinction seems to be between moments of constitutional rot, which still seems to provide some space, and moments when the prerogative state really emerges and prevents that from happening. So what might have these comparative cases suggest for understanding the United States today? Because I insist that that's also a comparative element that we have to bring in. Why while we might argue with Jack that the US has experienced a long period of constitutional rot and is not in a constitutional crisis, the question I ask is Azizhak correct to warn of the emergence of a dual state? Or as Justice Ketanji Brown Jackson, was she right to cite Ernst Fraenkel in her dissent in Casa versus Trump, which I thought was an extraordinary citation? The US is not now in a dictatorship, nor is it an apartheid state, or even in danger of a military coup. Yet we have witnessed the manifestation of zones of unaccountability being justified through repeated assertions of emergency conditions. While the most clear example has been the mobilization of ICE, its militarization and claims of absolute immunity, cited by, which was J.D. Vance's statement, the more subtle forms include the advancement of the theory of the unitary executive, the Supreme Court's decision to extend presidential immunity, and the increasing brazenness of the assertions that law and lawyers must serve the executive or be ignored. You just think of Secretary of, I think, War, he calls himself, who suggests that members of the lawyers in the military have no role. They shouldn't be speaking up. So despite the horror of the treatment by ICE of immigrants and citizens protesting the methods that ICE has used, including the killings of Renee Good and Alex Pretty in Minneapolis earlier this year, it's been the extraordinary solidarity among members of the Minneapolis community, including residents and elected leaders, that has evoked a national response that holds the potential of narrowing the zone of unaccountability that has been created by ICE. So if any institution in this new order, which is similar to those institutions of the past of unaccountability, it seems to have been the attempt to stand up ICE as an unaccountable institution. Now, granted, it's not aimed at citizens, but it's aimed at residents, and it has occasionally dragged citizens into its context. So by no means conclusive. Well, actually, I'll say one more thing about that, which is interesting, is I've got a daughter in Minneapolis and spent some time up there, and the distinction between the period of the George Floyd protests, when there were lots of little groups protecting the George Floyd Square and confronting the police, etc. The real character of that period was, in old terminology, quite ultra-left. It was, we're doing more than they are doing. My little faction is much more important than that little faction. And the comparison between that political moment and what has gone on now in this period against ICE is quite extraordinary. The same people, the same individuals, the same young people that I've engaged with are now saying, so you are delivering food and you are giving somebody a lift to school and we're chasing the ICE with our cars. We're all doing perfectly what we're doing. There's a level of solidarity and broad front acceptance, which is quite a change, a dramatic change from the same place, same people, just a few years on. A learning in terms of political mobilization that is quite extraordinary. And that's what struck me. So while by no means conclusive, the changing political winds and overreaching by the executive, as well as the federal structure of the US constitutional order, may prevent the emergence of a dual state here. Whether the constitutional rot that has facilitated the corruption and executive overreach may be challenged by democratic renewal and the assertion of legislative authority is in accordance with the separation of powers envisaged in 1787 is yet to be seen. But I am hopeful that, in fact, both the structure of the country and the way in which people are responding means that this attempt, and it really has been an attempt to create the space for a prerogative state, has been closed. Thank you.
I'm happy to go next. All right. So, thank you. I almost forgot the most important thing, which is the microphone. So in 2019, we had a conference at Drake where Sandy and Jack debated, and Sandy said the problem was we have an undemocratic constitution and we need to amend it. Jack said, no, actually those institutions protect us from bad things. And really the problem is just the political system is rotten. And I wrote a paper where I basically took Sandy's side for some different reasons. And, I've come to realize it took, Jack, it took me 7 years, which is pretty fast for an academic. But basically, I think you were right, more nearly right than I gave you credit for. So I appreciate Penny inviting me here so I can actually tell you this publicly. And I think in particular, what you got right, and which is so very important, is the small r Republican ideas are such a useful way of framing and thinking about where we are today. And that's what I really want to talk about today. I want to talk about what are the pathways of democratic erosion and America's small r Republican crisis. Now, in terms of thinking about those pathways, I'm actually going to be talking about another German lawyer and political scientist, also from the 19th. I think all of us are reading and thinking about these people right now. But Karl Lowenstein, right? And I don't know anybody who wrote in 15 pages, right? He wrote an article basically laying out what the pathways were of democratic erosion. And he said, look, what the demagogues of the 1930s relied on, or they relied on ethno-nationalist appeals, they relied on lies, with the idea was to divide citizens into two enemy camps, with the idea of making democracy unworkable, which kind of pushes the Overton windows, for dictators, right? And where he ended up the piece was saying that speech and elections become the Trojan horse by which the enemy enters into the citadel. And that's what I want to focus on throughout my talk today. And it turns out that modern autocrats, right? And this is so much the kinds of things that Kim writes about. They made some improvements, right, on the old model. They're not really looking necessarily to have a dictatorship, right? They kind of clothe themselves around the idea of democracy, but they want to eviscerate vertical checks. They say they rely on horizontal checks, but they still, just like the original model, they still rely on ethno-nationalist appeals. They try to tilt the electoral playing field, and that's a problem. By the way, like hello Donald Trump, right? And so I want to talk a bit more about elections and speech, because to me that is at the heart of Trump versus United States. What is remarkable to me is in the literature that was written about the case, they've all focused on the kind of rule of law issue. Do we have a king or so for king? And they've kind of forgotten that it was about an election. It's just remarkable that's been ignored in the literature in the cases as well. But that was at the very heart of Jack Smith's indictment, right? He said right in paragraph 3, the president has a perfect right to lie about the election being stolen because we have such an unusual protection for free speech in this country, exceptional if you like. But he just can't, break the law and seeking to subvert the election. That's what he thought until the Supreme Court decided the case and said, well, actually, maybe he can, right? Because presidents have absolute immunity for core executive functions, presumptive immunity otherwise. And the question I have is, why have so many people sort of ignored the election part of this? Why did John Roberts for that as well? And I think it's because when you scratch an American constitutionalist enough, that's what the oldest metaphor for thinking about the Constitution, it is a machine that would go of itself, right? It is the oldest, it's been around for the longest. And I think John Roberts very much belongs to that camp. And in the end of the year message, he said, I know people are worried about politics, right? But we don't need to worry because the Constitution is firm and unshaken, right? So what is that machine? Well, it's a remarkable amount of electoral and institutional complexity, right? Much more, when you look at all of this sort of long-term democracies as it's 1950, we have the most complex machinery of government of any of those nations. And for Madison, that was a way of curing the disease of the Republican government. But the person I want to leave with and thinking about that is actually the historian Richard Hofstadter. I think he was right. He said, this is the Constitution against parties. And what made the machine work was that one party would actually cede election to another. We were the first country to do that in 1800. That was a norm or a political convention that has stood the nation in good stead until 2024, right? And at this point, it's been wounded, and who the heck knows where we're going, especially after the immunity case. And so the question is, let's get a balance sheet of how that complexity works in an age of polarization. I think one way of thinking about it is the kinds of things that Jack has been saying is we shouldn't be that critical of it. It saves us from bad things. And I think a lot of progressives are perhaps looking a little more favorably upon that complexity than they had in the past. But it does one other thing, It puts Congress out of business. The executive gains a lot more power. And around the time when our politics started going haywire in the 80s and 90s was also the time that conservatives came up with the unitary executive theory. And it has sort of the three components, right? One of which is one person is the entire branch, right? That's the president. Two, a kind of an unbreakable chain of command from the president all the way down. And three, this is after Trump in the United States, the areas where the president can act where Congress is disabled have increased quite a bit. We're going to find out by how much. And what's on offer, right, in the Trump 2.0 administration is a patrimonial state. It's going to be one it's going to be difficult to dislodge. Why? Because Trump said it's sort of a doppelganger of democracy. It kind of looks like it, kind of talks like it, right? But it works in very different ways. And you see that in ways high and low, right? Anything from buildings to coins to portraits, low, high, which is just, graft. Or weaponizing the state. And let me just return a little bit to elections. Trump is the first president to systematically seek to erode the capacity of the state. That includes attacking elections. And elections are the canary in the Democratic coal mine. And Americans are taking the hint, and they're seeking in record numbers, right, a second passport. And so that's why I think we are in a small R Republican crisis. The idea of small R republicanism was that power would be downstream of the law, right? And I think what's happening is that the oldest piece of software written into the Constitution, which is a republic, is being overwritten by a virus in the form of the unitary executive theory, right? And so, for example, when Donald Trump was interviewed, he was standing in front of a portrait of John Adams. He said, "Mr. President, do you know that John Adams said that we have a system of laws and not of men?" His first reaction was like really? He said that? But his second reaction was, and he's not very much the realist, is, well, laws have to be administered by men. Hopefully they're honest men such as myself, right? I think the other one that's worth thinking about is Louis Brandeis. Louis Brandeis dissented in a case called Myers. He was in the majority in Humphreys. He believed in having restrictions on executive power to be able to fire people. And he gave an interview. So he said, imagine, he said, what would happen if Humphreys were not the law? And by the way, Humphreys will soon not be the law. Imagine what would happen if Humphreys was not the law and Huey P. Long were elected president. And Huey P. Long is the closest thing we've ever had to a dictator in this country, right? And you know what? We no longer have to imagine that because it's no longer a theoretical issue here in the United States. We are watching it every day in the Trump 2.0 administration, right? So that's why we have a Republican crisis. And I do think, and this is where I actually part company with Jack, is he's hopeful that it might get better in the future. I fear that it may be enduring, right? And I'll give two reasons. One would be the lessons of experience, and one is sort of just thinking about how constitutional principles. In terms of the lessons of experience, there's nothing unnecessarily that don't work together with a very messy, conflictual democracy in a patrimonial state. That has been the long experience of the global South. I do think the Republicans of Latin America were early, they were precocious in developing this sort of combination. I fear that may be our future self. Also, it's not clear to me that what happened in the past for us to deal with that corruption and build up state capacity is repeatable, right? We had a series of presidents who had cross-cutting groups that could actually bargain over reforming the state. I'm thinking of TR, right? Taft and Woodrow Wilson. And then very importantly, with FDR, you had two extinction level threats in the form of the Depression and World War II that got people to bargain over things. And that was a period when the sort of ethno-nationalist things that divide us were not very strong. Why? Because we ignored the issue of race. That's what we normally do when it comes to race. And on top of that, we were living on what Steve Miller's dream idea of immigration law in 1924. We weren't allowing anybody but, whites into this country, right? So they were able to bargain and do over that. In terms of the Constitution, someone mentioned that at the very beginning, it's the Humpty Dumpty principle, right? I mean, it turns out that one president with unitary executive theory can do a heck of a lot of damage, right, to state capacity. And it's not clear to me that it can be rebuilt that readily, right? It takes all the king's horses, all the king's men. It takes the president to Congress. The Supreme Court would absolutely be against this process, right? And will find ways to derail it. And also, it requires the building up state. You can get rid of democratic erosion in one election. You cannot build up state capacity in one election. It requires legislation that are sort of intertemporal bargains. And I think the point that Hamilton made in the Federalist, where he said, presidents play a role in, the Senate plays a role in appointments. They should play a role in removal as well. And he said the reason for that is it will just lower the stake of politics because it will make an election that much less conflictual. That is not our future, right? We will have remarkably high stakes elections going forward, and it will be remarkably difficult to build up the state capacity. And I worry that that it'll be an ongoing crisis.
Thank you to Penny for bringing us together, and thank you to Jack for all his contributions. So I wanted to call this Balkin in the post-colony. So we'll see how that goes. So I want to start with a puzzle about Jack's work, which is that why is it that a scholar who's so identified with American constitutional theory has been so useful for some of us who work on constitutionalism elsewhere, especially in post-colonial settings? Why has his work felt so accessible to those thinking about India, South Africa, and other constitutional orders that marked moments of rupture, hierarchy, and unrealized social promises? And how, at a moment when liberal constitutionalism seems much less secure than it did even 20 years ago, does this work feel clarifying but deeply discomforting? And I think the answer has something to do with time. Balkin has always written about constitutional law in a way that makes temporality difficult to ignore. Not time in the sense that doctrine rises and falls, chief justices come and go, but in the way that his work in constitutions are intergenerational projects that make claims on the future while inheriting damage from the past. They can be repositories of principle, but also of disappointment, improvisation in certain cases, and forms of deferred struggle. And I think it is this mode and this register of thinking that has traveled quite well. It travels well, especially to the post-colonial constitutionalism, because post-colonial constitutions are saturated and obsessed with time from the outset. The Indian Constitution was never a charter for limited government. It was drafted in the aftermath of colonial rule and partition under conditions of poverty, caste hierarchy, and entrenched communal violence, things that we still haven't gotten over. It had promised democracy to a society that had not remotely democratized its social life. It promised equality where humiliation was fairly ordinary and everyday. It promised secular citizenship under conditions in which religion had just helped redraw maps. So its task was to create a new political order. And the same is true of South Africa. The 1996 Constitution is one of the clearest examples we have of a legal order consciously writing itself against a history of domination, which knew that political transformation would not be enough. And this is the reason it's so ambitious about dignity, equality, and transformation. I constantly teach the preamble of the South African Constitution, even in my American Con Law classes. And that's why it remains so vulnerable to disappointment. The larger the promise, the more visible the gap between aspiration and lived reality. And I think this is one of the reasons that Jack's frameworks have been so generative, because his work takes seriously the fact that a constitution issues checks that it can't cash all at once. His accounts largely insist that constitutional meaning is worked out over time by institutions, political parties, courts, social movements, rather than simply being read off the page. And his account of constitutional redemption likewise treats constitutional politics as a struggle over whether inherited principles can be made to serve more egalitarian ends. Now, that basic style of thought has relevance for post-colonial orders, where constitutional text often bears the weight of a national refounding. Balkin's work on framework originalism treats the Constitution as a basic framework whose concrete content is built out over time, while cycles of constitutional time ties constitutional development to larger political cycles and episodes of rot and renewal. But I think the part of Balkin's work that has become most useful recently, and we've sort of seen this throughout the course of today, is his account and his language of constitutional rot. The idea, of course, landed with force because it named something that many people could already feel, but had trouble describing. Democratic decline in many places no longer looked like the old script. And in that sense, he joined an older line of thinkers like Arendt, Hofstadter, and even the crits who worried about democratic erosion beneath legal continuity. But his intervention is still quite distinct. CLS exposed how liberal legality reproduced hierarchy, and while Balkin was describing a slower constitutional debilitation, where polarization, distrust, and institutional failure hollow out democracy while the form remains in place. As Professor Shapley's work has persistently reminded us, it's not always suspension, rupture, an emergency rule, or that naked authoritarianism replaces. Often these forms remain and institutions become hollowed out over time. So Balkin is describing constitutional rot as the process through which republics become less representative and less devoted to the public good, even while formal institutions endure. And that's what made it so compelling, because it captured the ordinary texture of democratic degradation. But memory and authority also lets us see something else that now seems indispensable, that rot is both institutional and is also a mnemonic. Balkin's arguments that there are fights over constitutional interpretations are also fights over collective memory. Participants in what Charles Epp would call a legal support structure, in their interface with judges, construct a usable past. They preserve some inheritances, bury others, and present selective memories as constitutional authority. History on this account is filtered through legal forms, and present political needs. And Balkin argues that lawyers and judges invoke history selectively to construct authority for their positions and seek to undermine competing views, and legal reforms shape not only how they use history, but what they're able to see in it. Now, that insight matters tremendously for post-colonial constitutionalism. Because post-colonial constitutional orders are always arguing with history twice over. First, they argue with the official memory of empire. Then they argue over the national memory that comes after independence. So the Constitution emerges from an anti-colonial struggle in India, for example, but also from partition, caste hierarchies, I said earlier, and unresolved contests over who the political community even is. So constitutional argument in India has always been a struggle over the usable past, even when it hasn't always announced itself in those terms. What counts as the nation's true inheritance? A plural, anti-caste, secular constitutional founding, or a civilizational story in which the Constitution matters only insofar as it can be folded into a Hindu majoritarian past? That is why Balkin's work on memory matters so much here. It explains how constitutional authority gets made to seem ancestral and of a certain provenance, even when it is politically manufactured. And it helps explain why constitutional contestation in India often takes the form of disputes that at first glance look like arguments about culture or religion, but are also really arguments about constitutional memory. Who belongs to the founding story? Which injuries count as national injuries? What is remembered as restoration and what is remembered as betrayal? But none of that on its own quite gets to why the failures of post-1990s liberalism has so often produced majoritarian belonging than forms of redistributive transformation. That's a story that both of our sort of polities have dealt with. And this is the point that I want to put Jack's work in conversation with more post-colonial thinkers. Because if there's one thing that the last 30 years has shown us, in India and South Africa, and now very plainly in the United States, is that liberal constitutionalism has weakened in a strikingly patterned one. The post-Cold War faith that markets, rights, pluralism, and constitutionalism would all reinforce one another has worn quite badly. And when that settlement began to fail, when growth proved unequal, when institutions thinned out, and when rights discourse seemed incapable of addressing abandonment and material insecurity, the result was not a clean turn towards social democracy. It was a return or an intensification of politics organized around religion, race, ethnicity, caste, and the nation. India is the clearest case for me. If one looks at the post-1991 period, it is inadequate to say that Hindu majoritarianism triumphed merely because secular constitutionalism was always shallow or because majoritarian impulses were merely waiting under the surface. The harder truth may be that liberalization and constitutionalism were, for a time, imagined as mutually reinforcing. growth would stabilize democracy. Rights, in some cases, would blunt forms of social hierarchy. And an institutional modernization would likely deepen the roots of pluralism in our societies. But the social world that was produced by liberalization turned out to be far more jagged than that story allowed, because the benefits were fairly evident and material, but so were the exclusions. And I think in that world, Hindutva did, which is Hindu nationalism, did something politically potent by offering not just dominance, but also coherence, and offering injured majorities a story about who they were by parsing insecurity into belonging. Now, this is partially a story about ideology, but it's also a story about political economy. And it's also a story about memory, because one reason nativist politics has been so effective is that it has learned to narrate inequality and humiliation through a selectively remembered past and turns history into compensation. Now, the deepest lesson of reading Jack's work through authors from the majority world, which is a term I am trying to use now instead of the global south or the third world, is that constitutional redemption can't be achieved through fidelity to interpretation alone. And the gap between constitutional promise and constitutional reality is not primarily a failure of legal imagination, but a failure of the political economy. And it's structural, and it's also sewn into the founding settlements that traded transformation in the text for preservation of power in the world. This is, of course, a discourse that's present in both of our countries. That's something that we've chatted about at length. And scholars like Upendra Bakshi have shown us that constitutional meaning is made from below, in conditions largely that look like catastrophe, but that the very mechanisms of popular claim making are themselves capturable by those with greater juridical literacy and proximity to power. Dr. Ambedkar, who is also one of the founding fathers of the Indian Constitution, insisted that no political democracy survives on the foundation of social hierarchy, that a constitution asking the state to transform the society that has already captured the state is asking for a miracle rather than seeking a real mechanism. Akhil Mbembe also names what happens when that miracle, which is associated with the founding constitutional moment, fails. The constitutional order maintains its form while exposing surplus populations to conditions of death, producing a necropolitical reality beneath the transformative juridical surface. And authors like Tsepo Madlingzozi have recently demonstrated that with respect to the South African constitution, that when the land question, which is something that Heinz has written about extensively, and the capital question are settled before the constitutional text is written, the text's transformative ambitions are already circumscribed by the world that it was supposed to change. So together, these thinkers ask us to materialize constitutional possibility and insist that redemption requires not just a better reading of our foundational commitments, but the redistribution of land, capital, and social power, without which these commitments remain with what the majority world has often received them as. I want to now move to a slightly different register, and I want to move to the impact that Jack has had on my career in a pedagogic register. So one of the hardest things about teaching constitutional law in the United States right now is that our students are unusually alert to the instabilities of the stories that we've inherited. They're disillusioned by the triumphalist narratives that we as members of the legal academy had discarded decades ago. They can see the institutions acting in ways that are formally legal and democratically corrosive at the same time. So, before I started teaching constitutional law in the spring, I had a conversation with Jack. I hope he won't mind me mentioning this, but he helped me see that the right pedagogical approach to the present wasn't reassurance, but clarification, not flattening complexity, but telling students how to inhabit this world. And memory and authority has also mattered to me, especially here, because students are living through a period in which constitutional law is saturated with bad historical arguments. So students can sense that history is everywhere, but it's often in flattening, and it's being invoked in flattening, selective, and strategic forms. Jack's work gives one a way to teach that problem without turning it either into piety about the past or cynicism about the present. It lets one say that history in constitutional law is not just about accuracy in a historian sense, although accuracy matters, and Mark will testify to that. It's also about authority, why some stories of the past acquire legal force and some don't. And this matters a great deal because there's a real temptation when teaching in uncomfortable political moments, either to retreat into doctrine as if it were some form of shelter, or else to leap too quickly into denunciation and tell students that the whole thing is a sham. I don't think either move is adequate, and what students need instead is a way of understanding how constitutions can remain operative while becoming thinner, harsher, less democratic, and more available to capture. They need to distinguish among different forms of constitutional failure and to see that legal form still matters, even though it's not enough on its own. And Balkin has been helpful to me here because he doesn't force a choice between naive faith and total disillusionment. He provides a way for one to say that the constitutional order is hardly self-sustaining. Politics builds and degrades constitutional meaning. Decline is often gradual. Texts do not save themselves. And history itself becomes one of the great terrains on which constitutional struggle is fought. That is a great deal to have taught a generation of scholars and of students. So reading Balkin's work from India or South Africa, these tools don't become less useful, they become more contestable and therefore more interesting. Thank you.
I'm going to say just a few things.
Microphone.
Sure. I'm going to say a few things about, should turn that on too, I think, about my research. I haven't really prepared a full presentation here, but it strikes me that there's some gaps in what's been presented that might be useful to fill in. This panel is on comparative perspectives, and we really haven't talked much about Asian, well, Indian, yes, but Southeast Asian and East Asian constitutions. Many of the states that fall within that ambit are clearly dual states. We have civil societies that seem to function well, court systems that seem to function within them reasonably well, and yet many autocratic governments and the societies, many of them seem more comfortable, whatever that means, with autocratic governments because they've lasted for a long time. My focus has been particularly on Thailand, and not necessarily directly on its constitutionalism, but on the role of lawyers, especially human rights lawyers, and how they've tried to build a community which functions well and which can use the courts in a meaningful way. Their concern has been not so much about constitutions, but just the way that law operates in civil society and trying to create a larger field for law to actually operate in an equal and effective way within that society. But law doesn't operate in civil society, in modern societies, without some sort of framework understanding for how government interacts with the people, and that's where a constitution comes in. The question I began this panel with is, why do we have constitutions at all? I mean, the society that we're talking about here on this panel, and certainly in the US, are ones where constitutionalism seems deeply embedded, but that's not true in all modern societies. And in fact, some societies are still struggling toward stable constitutionalism, where it doesn't seem to be a tradition yet that's quite deeply founded. Let me talk a little bit about the history of constitutionalism in Thailand. Even though there's some ways in which this history is quite different from our experience in the US, there are other lessons which we might draw from, which illuminate things that haven't been talked about yet. The history I'm going to talk about goes back to the play The King and I, that beloved musical about a king of Siam, King Munk, who ruled until 1868. He's a real historical figure. And if you remember the play, there is the son of King Munk who comes in and makes friends with a tutor who teaches Munk how to live a little, among other things. That son, Chulalongkorn, grows up to be a modernizing absolute monarch, and in an act of defensive modernization. He's got France on one side, England on the other. He creates a modern state, an administrative state with institutions that mimic those in Europe, particularly civil jurisdictions in Europe, complete with bureaucrats, with ministries, bureaucratic courts, the whole 9 yards, but all really to serve a colonization project of his own, that is an internal colonization. I think India was one of the models that he used for how to set up the administration. And while there's a regularization of many of the bureaucratic procedures, it was also very top-down to give his rule effect. 1932, there's a revolution. Almost doesn't deserve that name because it's only conducted by a couple hundred people. There's no involvement of the population as a whole. Most people barely knew that this had occurred, but it displaces the absolute monarch. The leader of the revolution is one of the idealists that met in Paris salons in the 1920s with people who had been influenced by the Chinese Revolution, the Russian Revolution, by the revolution in Vietnam still to come. And ideas about socialism were percolating through this community. He went back to Thailand, attempted to establish socialist principles. He wanted a constitution and a socialist constitution. He failed in in both of those ideas. The king, who was sort of ready to turn over rule to a more modern and not democratic, but constitutional regime, agreed to a constitution, but one which in many subtle ways preserved the absolute powers of the monarchy. Much of the daily business of government could be conducted by a parliament, but in some critical respects, the king was allowed to enter the picture and make critical decisions. Since that time, in 1932, when Thailand became a constitutional government, I won't say constitutional democracy because there have been periods in which it certainly was not democratic. The country has had 20 constitutions, almost as many military coups. The country surely should be able to teach us something about constitutionalism, right? What it teaches us, though, is that there are many different kinds of authority which support a constitution. There's been a constant battle in Thailand between progressive forces, not a popular demand, not a progressivism coming from popular demand, but from intellectuals, leaders, many of them trained in the West, but not all of them, but who've admired changes in Asia, which have occurred in favor of socialism and governments not ruled by traditional monarchs or religious monarchies. And on one hand, these progressives who want constitutions which allow for more participation, and on the conservative side, people clustered around the king who want to keep a traditional social hierarchy in place and to prevent full-on democracy from occurring. Each one of the constitutions has been a resetting of that table, usually because of a realignment of power among elites. In the 1970s, however, there's a dramatic shift in which there's an uprising led by students for a more democratic government. And behind the scenes, the king is in favor of doing this. One thing to keep your eye on is where the monarchy is in the many constitutional changes. It turns out every one of the shifts in power is aligned with the monarchy in some subtle way through a cluster of networks and relationships that keep the authority of the monarchy somehow central to legitimating government. Move forward again. In 1976, this is going on much longer than I thought it would. Yeah, right. There are a series of coups which occur, take us up to 1997, when a fully democratic constitution is adopted. This is about the time that my research enters the picture. I'm interested in how lawyers respond to this and how they're going to put it into practice. The military reemerges in 2006 with a coup. It's clear that the king is still a center of power, that his religious authority as a Buddhist monarch can still move the military and move other elites to assume control of the country. Since 2006, there's been a continuing struggle, again, between these two forces, between religious authority centered in the king on one hand and more progressive forces on the other. The lesson I draw from this is that constitutionalism, legitimacy of a constitution, is supported by powers, they come from many different sources: popular consensus, tradition, in the case of Thailand, religion, traditional hierarchy among elites. When you say that there's been an erosion of normative consensus behind our own constitution, where were the norms coming from? What norms are we really talking about? What are the sources of that normative support? Is it a matter of normative support? Is it a matter of balance of powers behind the scene? What do we really think a constitution represents? I'm talked longer than I expected to. I'm searching for lessons in this history of a Southeast Asian country. I think it asks us to think a little more deeply about what supports constitutionalism and really what it represents. One person's constitutional rot might be another person's preservation of essential traditions underlying constitutionalism.
Thank you, Frank. I think we'll just open up questions. We'll take 3 questions and then you can answer, okay?
First, with regard to the general issue of dictatorship, one of Jack's notions is nested oppositions. And it seems to me that if you look at Clinton Rossiter's, I think, great book, every democracy includes within it elements of dictatorship, usually revealed during times of emergency, but not only. And so this requires some analytic notion of dictatorship. And I think Americans especially tend to think of dictatorship as Hitler or Stalin. And if we're not Hitler or Stalin, then we don't have dictatorship at all. But it seems to me that we have always had elements of constitutional dictatorship, which Carl Friedrich and Brzezinski distinguished from totalitarian dictatorship. And at present moments, I think that is emerging with special clarity. And apropos of Frank's comment, it strikes me as really very interesting. The assumption in Thailand, I gather, everything I know about Thailand, I just learned from you, is that the powers that be in Thailand, including the king, would have to be worried about the military as a constitutive group within the society. And one often reads articles about Chinese politics in which there's a suggestion that the president or the premier has to be, interested in the Chinese military. Whereas, ironically enough, I don't think we read many articles about that in the United States, which for me reinforces the notion of the present moment as a constitutional dictatorship. That is to say, the President of the United States, because of the tradition of civilian control, norm of civilian control, constitutional requirements, civilian control, whatever you want to call it, can order the military to do whatever he wants, the military would do it. And so, you talk about Donald Trump's or any other president's worry about Wall Street, the concern about the stock market, the concern about the farmers. You don't really read anything about his concern about the military. And then I think you say, well, is that a feature or a bug?
Great, thank you. There's kind of a thread that runs through all of your comments, and that thread has to do with the idea that there's more moving parts in a constitutional order than our theories currently say. We tend to look at constitutional institutions, we look at constitutional rules, we look at elections as also systems of rules and so forth, and maybe we even think about political parties in that context or the people as a whole. But the other moving part that all of you have kind of mentioned is what we used to call civil society, or some kind of mobilization of people outside the standard political parties. So like when Heinz was talking about solidarity, for example, that wasn't something that just runs through like the Democratic Party or through whatever the equivalent is. And when Miguel was talking about elections, it was that there was a kind of mobilization beyond the campaign itself. And this also goes to this question about, if you're going to have nativist and religious solidarity take over as a political force, I mean, somebody's mobilizing it, right? It's not just like spontaneous. So, and actually even with the student movement, Frank, that you mentioned, that all the way through there have to be not just masses that suddenly spontaneously come up with it, right? But they're civil sector leaders that have not yet positioned themselves as political actors by a social movement into a political space. And I think what we're seeing in a lot of the populist movements, Hugo Chavez and even Emmanuel Macron in France, right? They started as kind of charismatic single figures, swept in by a social movement, and then have to retrospectively construct a party to hold themselves together. That's exactly what Peter Magyar just did, by the way, in Hungary. He doesn't really have a party. Nobody has any idea who all the MPs were that they just elected. And so I guess I'm wondering whether what we're seeing as part of this constitutional breakdown or crisis is a disintegration of the organized political structures that link sort of aspirationally democratic publics with the political institutions, and so is it parties, is it something else? What's the role of social movements and the role of sort of charismatic leaders, who don't have a political position, thinking through how we imagine who the people are and how they feed into a constitutional order? Long question, sorry.
Last question.
I'll make it quick. I'm curious, if we think about amendments as pressure release valves, how easily or difficult should constitutions be to amend or replace? And second small question is, are subnational constitutions really constitutions?
I'd like saying just briefly for both Sandy and Kim, really helpful remarks. So one has to do with the role of the military. It's no surprise the military plays a big role in other countries. It's often the strongest institution, most organized, most bureaucratic. And it's not a surprise that civil society organizations have often been the trigger. I want to add a third factor here too, and that's globalization, that often neither one would become active without globalization. The military, of course, is supported often from abroad. That is, they get money. It's part of building colonies, but also the United States in many different waves, starting in the Cold War, but also after 9/11, poured lots and lots of money into building military organizations. Civil society organizations in Thailand, I'll just give you another little clip from the 1973 uprising, which sort of changed the picture, came about because universities were being built up as under a period of Americanization funding for universities in Thailand. All of a sudden, you got this massive surge of educated students who were just pissed off about the way the government was being operated. And other waves like that come, I think, linked to periods of globalization and cross-globalization influence. I'm kind of surprised that this would also be a period in which you think that civil society organization is declining, because usually point to the rise of social media as facilitating civil society organization. So, don't know.
I'll try to keep it brief. And as to Sandy's point, I think Americans are just hampered by not knowing what the hell goes on in the rest of the world, right? And so your point about, you're absolutely right. So the train to Hitlertown has lots and lots of stops. We're not going all the way there, right? And people don't understand that there's a line between dictatorship and democracy, which is very messy, and we're moving in a direction, right, and dealing with that. So I think that's important. We lack a term for in autogolpe, right, which is what we witnessed in 2024. It's not existing in the English language, right? So I think all those points are right. To Kim's point, I think that's such a important thing to remind us that we are dealing with charismatic leaders are nothing new. George Washington was a charismatic leader, right? And a remarkably charismatic leader. He just liked institutions, fortunately for us. But but what's interesting, and so you got to kind of disaggregate, I think, erosion from below and from above, right? And I think what's happening with charismatic leaders is less the problem with formal institutions, but it shows us the importance of political conventions. Again, something which is lacking among American constitutionalists, right? One of them was a norm that a party accepted. It's election laws. There's many more you can sort of multiply out. And so I think on balance, I think one thing that's missing, I think one of the weaknesses of presidential government, where it suffers in relationship to parliamentary government, is it's somewhat weaker on balance in terms of preserving those norms for a number of reasons. They invite outside candidates who have not been sort of socialized in politics, and that makes a difference in terms of those norms. When you look at the most successful democracies, the 22 nations have been said, about 20 of them are parliamentary. All of them have a head of government and head of state. And that was actually one of the reasons that was sold why you needed a parliamentary government, because one is your president is not the head of state, so it makes it harder for a demagogue, but also heads of state have reasons to care about those norms in a way that political actors really don't. And then the other is it's really useful sometimes. I know people go Americans go a little crazy. It's too easy to pass laws. But the reality is sometimes you really need to be able to pass them. It would be damn important for us to create some sort of distance between the AG and the president. That will not happen. That will not happen. And what the Supreme Court handed to Donald Trump on a plate was what every dictator in the world wants, which is to be able to fully weaponize the Department of Justice. And that is a disaster of the first order. That is a vile, vile decision. And that's the best you can say about it, right? And to Hank's point about, Article 5, anything is better than Article 5, right? I mean, that's easy, right? I mean, they never really thought about, how this would play out over time. They did think that amendments were important. And I think the reason why they're important is perhaps not so much the reasons, I'm deeply sympathetic to Sandy's position, but I think what's important is it just from time to time, one way you get people involved in politics is because they take ownership of the Constitution. And yes, all those subnational rules really matter. The problem that we're having is we have a system that divides power more than any other civil democracy in the world, and politics has become nationalized. The system is just not built for that kind of politics, and that's why we're seeing all those problems.
Yeah, I mean, in response to, I'll just say two things. The first is sort of how constitutional design can't solve all the issues that we encounter. So even with the difficulties of Article 5, we're now seeing a case where everything is judicialized. Whereas if we look at, if we look comparatively at India, which has had over 100 constitutional amendments, there are still ways in which, so currently there's a debate going on about a constitutional amendment that would increase the size of the lower house of parliament, which would it would make northern states more powerful than southern states. Northern states are, more aggressive, et cetera, et cetera. So it's being rammed through. So in some senses, the Indian constitutional system is more small d democratic in that these national debates are occurring at a legislative level rather than at a judicial level, but we're still seeing a lot of opposition, to this. There's a lot of political discourse that's ongoing, and so constitutional design can't obviously solve everything. And to Kim's point, it's interesting because I think that there's this whole thing in large parts of Western democracies where parties are being hollowed out and traditional party structures have collapsed. This is not the case in India. We have the Bharatiya Janata Party is the largest and most successful party machinery. It's the same with the African National Congress, which regularly changes who it puts up as a presidential candidate. So I think that there's a way in which maybe it speaks to the difficulty of doing comparative law and trying to sort of do cross-country comparisons. And when it comes to things like social movements, right? I mean, undergirding the success of the BJP is the RSS, which is this massive paramilitary. Some would describe it as, it's a social organization. So there is a wellspring of ground up support, and it's also difficult to say whether it's a recession of the state where these social movements have come in or not, or whether these institutions just never existed in the first place. Because the traditional story is one of like state recession, but that clearly hasn't played out in India. So I don't think I have a very satisfactory answer, unfortunately.
Just shortly, Sandy, precisely why I raised Frankel and the question of the prerogative state is I agree with you that the democratic state has autocratic moments, and it's part of democracy that there is this kind of constitutional dictatorship at certain moments. And I think the distinction really is the emergence of a prerogative state where there is an element that is totally unaccountable, and that distinction between what is normal law, etc., and the time when they can just walk you out of the door and you never come back. And that becomes a distinction which really underpins a really authoritarian system. And I think that's why I focused on that. Kim, when we talk about civil society, what's interesting is these autocratic states, one of the first things they do is try and cripple civil society, right? Take away funding rights, prevent external funding for civil society, all the ways in which they try and undermine civil society. And yet at the same time, in a kind of context of South Africa, where we've seen, a certain amount of autocracy, particularly under Zuma, they were trying to do exactly that. But civil society managed to mobilize and stop that. And by exposing the corruption, the fact that we had that kind of media ability to actually bring Zuma down, with the threat always that the party itself would lose power. What's interesting now is as the party is disintegrating and losing power anyway, what's going to happen? That's the moment now where Ramaphosa has very little power within the party. And so the party is effectively disintegrating. And Hank, the question of amendments and lower level constitutions, one of the solutions at the end of apartheid was to create provincial constitutions to allow Buthelezi a way out in KwaZulu-Natal, to allow them to recognize the king in KwaZulu-Natal. And what's interesting about that is that didn't solve that problem. It created a new one. South Africa now creates more kings and queens than we've ever had before. Right, and so creating a separate kind of constitutional order as well. Thank you.
Thank you to the panel. So this panel is now 5 o'clock, and it reminds me of the New Yorker cartoon some years ago, where two blokes are standing at the water cooler. Remember, before pre-pandemic in the office, you'd be standing at the water cooler, and the one says to the other, I try to keep the caffeine buzz going until the martini buzz kicks in. We're saying that we've got the conversation, and Jack will make some concluding comments, and then there will be some wine at the end. So I know it's the end of the day, a little bit of energy. We'll take a 5-minute break and then come back. Thank you.